I just have to say, Dee, thank you for believing in justice, because it's such a big part of why it happens. Thank you, thank you, thank you. And of course, thank you for being here tonight and the love that shines through in your advocacy. I also want to say hi, everybody. Great to see you. Thank you for being here tonight. Okay, so tonight, we are celebrating the anniversary of something that once seemed positively impossible. So let's do a little history. Think back, maybe even 50 years ago, 1973. It's just a few years after the Compton cafeteria and Stonewall riots. You know, a few highlights. U.S. Supreme Court affirms the conviction of 2 men for sodomy. Kentucky court denies a marriage license to a same-sex couple. Medicaid Board of Review rejects coverage for transgender health care. New York's City Council rebuffs a gay rights law. Awesome. Then it gets worse. You know, as the 70s rolled on, in Florida, Anita Bryant begins her Save Our Children campaign to overturn local non-discrimination laws. In Boston, police and prosecutors launch a coordinated effort to entrap gay men at the Boston Public Library, and GLAAD is founded. For much of the 1980s, the government did nothing while thousands died from AIDS, HIV. So how did we get from there to this celebration tonight, to waves of positive change for LGBTQ+ people and the end of the HIV epidemic within sight? And how did we get to marking 20 years of being the first state to have legal marriages because of an awesome state Supreme Court? Yeah. And I will never tire of saying thank you to the Supreme Judicial Court for having the courage to be first. Thank you, Chief Justice Margaret Marshall. But we got here in part because we, the big we all kept at it, supporting one another, growing our movement for love and for justice, and engaging with the public to advance our basic promises in this country of liberty and justice for all. So GLAAD's creation in 1978 certainly helped. It enabled us to speak in our own voices in the courts, in legislatures, in the court of public opinion. And then, incredibly, as we just heard from Dee, extraordinary people challenged injustices. Deirdre Farmer, the Goodridge plaintiffs, who we honor tonight, and the attorneys, organizers, and doers of all sorts with whom GLAAD has worked for decades. And I have to say, often what separates the possible from the impossible is a plan. So Goodridge versus Massachusetts Department of Public Health wasn't the first marriage case, and nor is it the end of the story. GLAAD had supported the Hawaii marriage litigation, and then our own plan began to unfold in Vermont, where with co-counsel we filed Baker versus State of Vermont, and that's a case, long story, resulted in the nation's first ever civil union status, which is a big deal. But then, 14 extraordinary people sued Massachusetts for denying them marriage licenses. And we translated lessons from Vermont to reach an historic breakthrough, again, via the Mass JC and its very courageous 4-3 ruling, and the first legal marriages in the United States of America. So that was really awesome, but it did trigger a bit of a blowback. So we had the president, we had the Congress trying to amend the Constitution, our own governor at the time, and persistent attempts to reverse the decision by a constitutional amendment in Massachusetts. But what happened? Instead of getting beaten back, We built the foundation of a national movement, and we kept going. Connecticut's Supreme Court ruled for us in a 2008 case argued by GLAAD attorney Ben Klein. Happy 15th anniversary, Connecticut. And with state partners, GLAAD worked on its plan to win in all New England states by 2012. In Vermont, New Hampshire, and Maine, we had the first in the nation state marriage laws, and then Maine won the first ballot measure in 2012, and Rhode Island's law made it a wrap in 2013. These are all things that even a short time ago, people believed were impossible. So GLAAD also took the fight national in 2009, challenging the Federal Defense of Marriage Act. We won the first rulings at the Federal District Court and the Court of Appeals levels, and we created a template for the ultimate Supreme Court victory against DOMA in 2013. There are a few other anniversaries tonight, including a congratulations to our plaintiffs from Massachusetts, from Vermont, from Connecticut, and New Hampshire in our DOMA litigation. Congratulations to all of you. 10 years. So after DOMA fell, GLAAD supported cases nationwide seeking marriage equality. We were asked at one point to join some Michigan lawyers in representing April DeBoer and Jane Rouse from Michigan. And by 2015, we were Supreme Court bound to argue for the equal right to marry nationwide. And I think you know where that one went. So with all this, we are nonetheless now facing some of the fiercest anti-LGBTQ plus attacks of our lifetimes. Now, granted, there are people who have questions about our community, things they don't understand. I would encourage you, please, to engage in a way with people who have questions, to invite more conversation and not less. But I really want to distinguish those questions and people learning and trying to understand from what also is, in fact, a separate, enormous, coordinated effort among many organizations to reverse all of the gains we've made since the last century on gender and sexual equality. GLAAD does have a plan. With love and justice, fight forward. Want to teach your kids history? Well, right now, 7 states and many local policies order educators, don't say gay, don't say trans, don't acknowledge LGBTQ humans as a part of humanity. GLAAD attorney Chris Urchel is part of a team of lawyers in New Hampshire challenging a law there that prohibits teaching about both racial diversity and LGBTQ inclusion. Want to hire someone to design your wedding website? Well, you know some places not to go. A Supreme Court decision called 303 Creative versus Elenis opened the door for certain creative businesses to discriminate against LGBTQ plus customers. GLAAD, with 2 new legal fellows who are here tonight, Ben Marcus and Courtney Doherty, is pushing back hard on attempts to roll back our hard-won constitutional rights. Among other things, many other things, we are aiming to prevent an extension of that ruling into an open invitation to harm LGBTQ people in the marketplace. Do you want to protect yourself, your partners from HIV? Well, a case in a federal appellate court in Texas would make it harder and more expensive for people to get PrEP and protect themselves. So after years of helping to expand access to PrEP throughout New England and with some successes in Maine, Rhode Island, and hopefully soon here in Massachusetts, GLAAD is arguing a basic point in our brief to the Fifth Circuit Court of Appeals. The worst way to prevent HIV is by making PrEP harder to get. Okay, Hope they get it. So I also just want to say, there really is no way to overstate the current threats. Our entire community faces revitalized prejudice. The tip of the spear is directed at transgender people, and outrageously, at transgender young people. 583, to be precise, anti-trans bills have been introduced in this past year. And while we have blocked over 90% of them, big we, too many have been passed. But we are planning, not capitulating, because GLAAD, of course, has been leading on these issues for decades under the leadership of Jennifer Levi. Over 20 years ago, we won a lawsuit that established protections under sex discrimination law for transgender people. That's 20 years ago. That important case laid the groundwork for the 2022 Bostock Supreme Court ruling that sex discrimination laws prohibit mistreatment based on both sexual orientation and transgender status. In 2010, GLAAD and co-counsel won recognition in federal tax court that transgender people should be able to deduct their out-of-pocket costs for essential medical care just like any other taxpayer. It was a big breakthrough. And in 2014, we won the first state high court ruling in Maine that trans students must have access to school facilities, including bathrooms, just like their peers. And as Dee mentioned, in the case of Kesha Williams in the Fourth Circuit, a transgender woman who experienced horrific abuse in a men's prison, but won a case under the Americans with Disabilities Act, well, of course, Virginia petitioned to the Supreme Court review, and the Supreme Court said no. We'll take it. That's a victory. So now GLAAD is in the thick of the fight against pernicious laws that stand in the way of parents being able to support their transgender children. We are heading to trial, first in Florida next month, and later next year in Alabama, to stand with the parents, transgender adolescents, and their families to do everything we can to overturn these harmful and baseless laws. In really hard times, when the challenges feel insurmountable, it's important to remember some of our history. Number one, there are always losses on the way to wins. And number two, those wins were never inevitable. They're the result of a lot of things and a lot of hard work. And what helped us through those losses was the kind of transformative change we were making, the strength we drew from one another, and growing a movement. Our hopes and our dreams for a more just society really matter, as we just heard so powerfully in Dee's remarks. At one time, during the whole marriage equality round one fight, over 40 states in this country, that's 40 plus states, had either laws, constitutional amendments, or both that said our relationships were unworthy of recognition. In 1986, the Supreme Court upheld sodomy laws that subjected people to 20-year prison terms for having sex. And yet, against all odds, we overturned those laws, and we will overturn these latest anti-LGBTQ laws. We will always find a path forward, no matter what is thrown at us. And that's good, because right now this barrage of bad state laws affects all of us. Bathroom bans, medical bans, book bans, drag bans, don't say gay or trans laws, along with challenges to non-discrimination laws, supportive schools, racial justice, marriage equality, to name a few. and they all ooze from the same pen. To be clear, our opponents do not distinguish among gay, lesbian, bi, trans, queer, non-binary. As Nadine Smith said from this stage last year, what starts in the South does not stay in the South. They are attacking and lying about our whole community, telling us who we can and cannot be, that our lives do not matter, and that we should shut up about our families. As Dee said, no silence. We need to speak. It's a time to speak, to stay united, and to leverage both those hopes and dreams that we have, along with our collective experience, and funnel that into future wins that we are going to make happen. So last summer, just to bring up some sore points, the Supreme Court abandoned a constitutional commitment that individuals and not the government control our bodies. Not only did the Dobbs decision eliminate abortion as a fundamental right, it undermined gender equality, and its flawed reasoning threatens other rights like birth control, consensual adult intimacy, and marriage. But the pushback has been strong. The Respect for Marriage Act is now federal law. And the Dobbs opinion continues to spur voters across the country to protect reproductive justice. Then this summer, the Supreme Court abandoned a constitutional commitment to affirmative action in college admissions, something previously understood as a necessary counterweight to widespread racial inequities. But that is not the end of the story. The majority opinion, thanks to deft questioning by Justice Jackson, had to acknowledge that race can play a role in a student's experiences and the contributions they may yet make. That means businesses and schools can continue holistic review of the person, because that person is also part of their identity, and their racial identities, their LGBTQ identities are an important part of who they are. So it's not game over. Now, in the healthcare ban litigation led by Jennifer Levi, we've had some extraordinary victories. In Alabama, a judge appointed by President Trump saw that shutting down medical care for transgender young people harms families. We are now seeking rehearing after a bad appeals court ruling because we are not giving up on those families or on our community. This is all to say that losses can be disappointing, but they can also be the seeds of change, and we are determined to leverage that change. In Maine, and this is an example of an opportunity, in Maine, GLAD worked with partners this year to pass a law that lets transgender 16 and 17-year-olds get essential medical care when denying it would be harmful and their parents don't yet understand their needs. I want to thank Representative Sheehan, who sponsored the bill, and Representative Moonen, whose committee made it happen. GLAD also stopped dozens of bills targeting LGBTQ+ students and young people last session in Maine, New Hampshire, and Rhode Island. And GLAD's Polly Crozier is leading GLAD's successful work to bring legal security to vulnerable children and families through updated parentage and adoption laws. Yes. We hope we are on the verge of passing the Massachusetts Parentage Act and having those updated laws in every New England state. So of necessity, GLAD is on both offense and defense. So beyond 303 Creative, we are working to make sure non-discrimination protections are enforced in jobs, in housing, in public accommodations, wherever barriers and prejudice would otherwise thwart people's ability to live their lives. And in an employee benefits case, soon to be filed in federal court, we are again seeking to stymie a big company's use of religion to justify discrimination. We are also, after years of suing schools, we're backing schools that support LGBTQ plus youth. Cases at the First Circuit and New Hampshire Supreme Court seek a new constitutional rule requiring schools to out students without regard to the learning environment that would create trust and relationships or student safety. Now, to be sure, schools should and do encourage young people to share important parts of themselves with their parents, but in the end, we have to be able to control to whom we come out, when, and where, and that's the rule we're arguing for. With partners, we also recently submitted a brief in the Fourth Circuit Court of Appeals on behalf of a Maryland school district being challenged over picture books in the classroom with LGBTQ people and families in the books. Our brief shows that teaching students that queer people and families exist is not sex education or indoctrination. So to the contrary, it is necessary for schools to create welcoming, inclusive environments for all students, and especially LGBTQ plus students and students with queer families and family members who face heightened risks of bullying and isolation. We are not going to be dragged back. And I say dragged back because 20 years ago, almost 30 years ago, we had to make these same arguments in federal court in Massachusetts when a local community member in Amherst challenged the beautiful display of the Love Makes a Family photo exhibit in an elementary school. And we are prepared to keep litigating this and keep winning it until it is no longer an issue. So as I close, let me say this. There is going to be some rough sledding as we head into 2024. And I am not a patient person, but I've had to become impatiently patient. And in my 33 years at GLAAD, I've learned that no victory or defeat is ever truly final. No matter the outcome in a particular case, what matters is staying engaged, staying positive, staying true, and standing up for our values of freedom and liberty and equality. All of us have these opportunities. So to be sure, we have work to do. We're not where we want and need to be. But as we travel, let us remember how far we've come as fuel for the fights ahead. What seems impossible can be done. And now with you, we are going to do the impossible again. Thank you.